And joining us in the final session of this series, we are lucky enough to have the renowned art lawyer Pierre Valentin, who is going to be exploring the legal frameworks that keep an artist's practice secure. Pierre will discuss the vital importance of copyright and how to navigate the risks inherent in gallery relationships and commercial contracts. Drawing on over 25 years of experience, he will share insights into what happens when things go wrong and how robust contracts can prevent disputes before they begin. So thank you very much, Pierre, and I'm going to hand over to you. Just a quick note to everybody joining us. We will be taking most questions towards the end of the presentation, but if it's a very pertinent to a point that Pierre's making, I will, of course, ask that question for you. And please place them in the comments. Thank you.
Thank you, Arita. Thank you so much. I'm very, very happy to be here today. And I look forward to this 45 to minutes or maybe a little bit longer session. I propose to spend about 15 minutes on copyright and then the rest, maybe about 20 minutes, 25 minutes on relationships between artists and their galleries. There will be time for questions, and I know Arita will do a splendid job at moderating, curating. We can't guarantee, of course, that all questions will be answered, but we'll do the best we can. Before I start, I'd like to make a very important fundamental point, which is this. Each country has its own laws. And as an English lawyer, today I will describe how English law works. Don't assume that the law is the same in the UK and outside the UK. It might or it might not. This is a challenge for artists and the art world at large because art knows no borders. Of course, if you are an English artist only working in England, that's not going to be a major preoccupation for you. Although, of course, if you show your art on social media, well, potentially you expose it worldwide, and that has legal implications. And of course, as well, if you work with, say, a gallery in Japan and one in North America, and you're based in the UK, that will inevitably raise questions of which law applies to those relationships. Having said that, let's turn to copyright. Copyright doesn't protect ideas; it only protects the expression of ideas. In other words, it's only once your ideas are recorded on your medium of choice that copyright kicks in. Copyright law varies from country to country, annoyingly, so bear that in mind. In the UK and the EU, copyright is automatic. What that means is you don't need to do anything. As soon as your idea is recorded on your medium of choice, that's it. You are copyright in that work vests in you, and there's no need, for example, to register your copyright anywhere. Bear in mind that that's not the case everywhere. In the US, for example, whilst copyright is also automatic to a certain extent, there is a register of copyright where many copyright owners decide to record their copyright. That can be important. For example, if you want to sue someone for copyright infringement in the US, you have to have registered your copyright in the first place. So bear that in mind. Copyright gives you, as the creator, a bundle of economic rights. They're not all listed on this slide, but the most important rights are there. It gives you the exclusive right to authorize or prohibit others from copying your work. to communicate your work or issue copies to the public or to adapt your work. Special case of photography, I thought I'd mention that if you take the photograph of the work by another artist who is within copyright, there are two copyrights in your photograph. There is your own copyright in the photograph itself, and there is the copyright of the work you have photographed. What that means in practice is if you want to copy your photograph or communicate it to the public, you need a license from the artist whose work you photographed. Another situation that I thought I'd mention is employment. If you are in an employment relationship in the UK, copyright in the works you create during that employment relationship vests in your employer. Contrast that with a freelance relationship where you simply provide services. In that case, typically, unless your freelance contract provides otherwise, copyright in your work will vest in you as the creator. So bear that in mind if you ever enter an employment relationship. Of course, it's not against the law to provide in your employment contract that a copyright in some or all of the works you create within that employment relationship vest in you as the author. That's a negotiation. The duration of copyright in artistic works is the life of the author plus 70 years from the end of the calendar year of their death. There are exceptions to copyright in the UK. Again, this is not a full list, but by exception, I mean that in certain cases, it is possible for someone to copy your work without your permission. And the main exceptions are on this slide. Criticism or review, that's an exception that's often used by museums who publishing catalogs for temporary exhibitions, for example. Reporting current events, that's more for the press. Caricature, parody, or pastiche, another copyright exception. Non-commercial research and private study, and reproducing artistic works for the purpose of advertising their sale. If you look at an auction catalog, for example, for a contemporary sale, you will find that many works, contemporary artworks, are reproduced in the sale catalog. These works are generally protected by copyright. However, the auction house did not require a license from those artists to reproduce their work in the catalog because the catalog is there to advertise the sale of those artworks. That's an exception. Many exceptions are subject to what's called the fair dealing condition. So it's not enough to say, oh, I don't need a license from the copyright owner because my copying is for criticism or review. In addition, you will have to satisfy the court if there is a dispute that your use of the works was fair dealing. Fair dealing, there are a number of conditions. One will look at the amount of the work and that was taken, the amount of the work that was taken, the importance of what was taken, and whether the dealing was commercially motivated. You may have heard of fair use. Fair use is a different concept. It's a US principle. And it's not quite the same as fair dealing. I mean, we could talk about this for hours and hours. Fair dealing is strictly limited to the UK exception, so it's fairly narrow. Fair use is an open-ended, flexible defense that's used in the US to justify the use by someone of the works of another person without a copyright license. I won't say more, but happy to answer questions on that later. And finally, on copyright, I thought I'd mention briefly what's known as text and data mining. You're probably familiar with that in the age of AI. Text and data mining is the automated process of extracting useful information, patterns, or relationships from large data sets. And this is needed by AI models to train those models. Now, in the UK, for the time being at least, there is an exception for non-commercial research. What that means is that if you are a university or any academic institution, you can text and data mine without copyright, without consent by the copyright owner, if it's for non-commercial research. But there isn't a TDM exception for commercial use in the UK. What that means in practice is that the ChatGPT of this world, who monetize their AI systems, cannot text and data mine without a copyright license. Now, the question is whether they seek a license in practice. That's a big issue right now, and we know that many AI systems hoover up tons of data, many of which is protected by copyright without consent. Just so you know, in the EU, they have a TDM exception for commercial use. In other words, in the EU, AI models can go and hoover copyright protected material, but there is an opt-out exception. So as an artist in the EU, you can say, stop, I don't want my copyright material to be hoovered up by AI models. And if you say so, you opt out. Again, in principle, AI models can't hoover up your work without your consent. Moving swiftly to the relationship you might have with galleries. First question I thought I'd ask is why do you need a written contract with your gallery? And I hear this all the time from artists who say, oh, I don't want anything in writing. It's intimidating. I don't feel comfortable. And from galleries saying, oh, no, this is all done on trust. We don't want anything in writing. The issue is this: whenever there is a business relationship, there is a contract. Either you see the contract because it's recorded on a piece of paper, typically, or you don't see it because it's an oral contract. You meet, you discuss, you agree, nothing is recorded in writing. The problem is a business relationship without a written contract is like a building with a weak foundation. On the right-hand side of the slide, I thought I'd show you an image of Fonthill Abbey, which was built for William Beckford in the 19th century. He was known as England's richest commoner. The problem was he was very impatient. He wanted this building built very swiftly, and the foundations were weak and it crumbled. you don't want that with your gallery. Looking on the left-hand side, you see a blueprint. That's what your contract is there to achieve, to provide structure, clarity, guidance, so that everyone is on the same page. You walk down the same you walk in the same direction, down the same path. Now, this is a slide which is really critical if you want to understand the legal relationships when you work with a gallery. You have three contracts effectively, and I assume here, of course, that the gallery is mandated to sell your work. It could either be that you have a long-term representation agreement with the gallery representing you over a period of years, or it could be simply that you have agreed that the gallery will do a show of your work. That doesn't really matter. You have three contracts. The first contract is between you and the gallery. I've called that an agency agreement because that's what it is. You are the principal, the gallery is your agent, and you agree that your agent will market and sell your work. Then you have contract number two, the sale agreement. That's between the gallery and the buyer of your work. The gallery, of course, is selling on your behalf, but that's the contract, the second contract. And the third contract is directly between you as the artist and the buyer. Let's call it also a sale agreement. That sale agreement is concluded via the gallery, but nonetheless, legally, it's a direct agreement between you and the buyer of your work, and it's by that agreement that ownership in your work will pass from you to the buyer. So three agreements there. Terms that are typically found in written agreement between artists and primary galleries. First question is this an exclusive? Is the gallery representing you exclusively, or do you retain the right to sell works directly or through other galleries? That's an important point. Territory. Are you saying to this gallery, you are only selling my work, say, in Europe, or is it a worldwide mandate? Pricing and discounts. What prices is the gallery selling your works at? And is the gallery authorized to give buyers a discount? And if so, how much? The gallery's commission, obviously, that's a key term of the contract. Typically it's 50-50, but of course we know that the more famous and desirable the artist, the larger the artist's share will be. Sometimes 60, 70, or sometimes even 80% will go to the artist, with the gallery keeping the rest. Who is going to pay for sales and marketing costs? Typically, it's the gallery. Who is going to pay the cost of production? That really depends on the arrangement between artist and gallery. Payment to the artist. When will that happen? How long will the gallery sit on your share of sale proceeds before paying them to you? Who will be in charge of packing, shipping, storage, and other logistics? Passing of ownership. At what point will ownership in your artwork pass to the buyer? Quite often, in the contract between the gallery and the buyer, that was contract number 2, there will be a clause that says that ownership will pass to the buyer when the gallery is paid. So the minute the gallery is paid, you are no longer the owner of your artwork. The gallery is. And we'll look at why that is important in a minute. Passing of risk of loss or damage. When is the buyer responsible for loss or damage? And that is the point when typically there is an expectation that the buyer will insure. It can be, sometimes it is the case that ownership and risk pass at the same time. Often risk will pass to the buyer when the buyer collects the work from the gallery. That's a contractual conversation. It depends very much on what the gallery is saying to the buyer in the gallery's sale contract. Reporting and disclosure. Reporting, by reporting, I mean what information will the gallery provide to you and how often? And by disclosure, I mean, will the gallery disclose to you the details of the buyers of your works? That is quite a controversial and difficult area. Ideally for you, the contract will say that the gallery must provide you with full details of buyers of your work, because in the future you may want to contact them, you want to be able to trace your work. If you want to lend the work to a museum, you want to know where to go for that. Equally, galleries may resist disclosing that information. Again, that's a negotiation. Duration and termination. How long will the relationship last? If it's a representation arrangement, it can last years. If it's just for a show, it may last a few months. That's a discussion. And in what circumstances can either the artist or the gallery terminate the relationship? And what are the consequences of termination? So what happens when the relationship is at an end? Obviously, as the artist, you want your the artworks back, the artworks that haven't sold, and you also want the gallery to pay you any outstanding share of sale proceeds. There's often more to it than that, and I'll give you an example in a minute. And finally, last but not least, and for a lawyer, this is very important, what law governs the relationship with your gallery? And if there is a dispute, where do you take the dispute? Now, the governing law becomes relevant if if the relationship has an international element. So if you are in the UK and your gallery is in the UK, as I was saying before, governing law is the UK, and you don't necessarily have to say that. Dispute resolution, but if your gallery is in a different country, that's when it's important to agree which law will govern the relationship. Is it English law, your law, or is it the law of the gallery, say the law of Mexico or the law of Korea? Dispute resolution, the question here is, if there is a dispute, will you go to court or will you select a different dispute resolution mechanism, typically arbitration? There we go into sort of a legal conversation, but it's one that's important to have, because there are pros and cons of going to court. There are pros and cons of going to arbitration, and mediation ought to be considered. Mediation is another type of dispute resolution, which is more flexible and is less confrontational, if I can put it that way. Now, I'd like to address 2 points finally. The first one is the risk that your gallery goes insolvent. And unfortunately, as you probably know, a number of important London galleries have gone into insolvency recently. And that can be a disaster for artists because quite often when the gallery goes into insolvency, it owes significant amounts to its artists, shares of sale proceeds that have not been paid by the gallery to the artist. The problem there is artists in an insolvency context are what we call unsecured creditors. That means that they come last when the liquidator pays off creditors. So the principle is that the liquidator pays himself or herself first, and then with what's left, the gallery's secured creditors are paid first. Secured creditors typically involve banks. The revenue may come in there, and they will be next in line. And unfortunately, artists come last. And in my experience, in a gallery's insolvency, artists can lose a significant amount of money, or they may have to wait for years until they receive a small share of what was owed to them. Now, the question is, what can you do? How can you protect your position? Your position if the gallery goes bust. One thing you can do is require the gallery to segregate your share by keeping it in a separate bank account. Now, you might be interested to hear that in New York, that's the law. New York galleries are required by law to keep artists' share or shares in a separate bank account to protect the artists in case the gallery goes bust. Why? Because if your share is in a separate bank account and is not commingled with the gallery's own money, then you stand a much stronger chance of recovering your share. The issue arises when the gallery has one bank account in which everything is mingled, their own money and their artists' money. That's when the problem starts. Now, you may not have the commercial leverage to insist on the gallery operating a separate account, but that is a good solution if you can do it. A second option, which is perhaps easier, if you have a written contract, is to establish an express trust in that contract. What you would say in the contract is that the gallery holds your share of sale proceeds on trust for you. That needs to be expressed. So there needs to be language to that effect in the contract. Therefore, you need to have a written contract with the gallery for that to happen. And if there is an express trust, then you can argue that this amount of money is yours and, put pressure on the liquidator to pay it across to you because you would argue it was never the gallery's money, it was always your money, even if it ended up in the gallery's own bank account. And if you can't have the express trust or the separate bank account, then this is a practical solution, ensure that the gallery pays promptly, and if there is a delay, you harass them until they pay. If a gallery takes time to pay, finds excuses, delays payment, in my experience, that's a red flag. And you need to act because that could mean that the gallery is in financial difficulty and the risk of losing your money is significant. And finally, I'd like to talk briefly about what's known as the right of first refusal. What is the right of first refusal? It's a right that is typically recorded in the contract between the gallery and the buyer of your work that says something along the lines of, if you, the buyer, decide to resell this artist's work, you must give me, the gallery, the right to buy it from you first. Now, there are advantages. There are advantages for you as an artist in having that type of clause in the contract between the gallery and the buyer. The main advantage is that it reduces the risk of what's known as flipping. Flipping is when a buyer buys an artwork on the primary market, so directly from you through the gallery. And 6 months later, the buyer then typically consigns it for sale at auction, generally because the prices of your works has gone up significantly, and the buyer decides to make a quick buck. Now, that's not generally that's not in your interest as an artist, because you want to control the price of your works. You don't want the prices to go up and down dramatically over short periods of time. So there is something to be said for the right of first refusal. But of course, on the other hand, who makes the profit? It's going to be your gallery. Because if the right of first refusal is exercised by the gallery, effectively the gallery buys your work back from the buyer and then resells it at a profit, and the profit goes in the gallery's pocket, unless you have negotiated with the gallery that if they exercise the right of first refusal, you go 50-50, for example. So 50-50 of the profit that the gallery makes when reselling your work goes to you, goes to you, and that, I think, would not be an unfair outcome. Now, one question that often arises, and the answer is not always straightforward, is the right of first refusal enforceable by the gallery against the buyer? The situation that typically arises is the buyer decides to sell at auction without giving the gallery the right to buy it first. And the gallery goes to the buyer and says, wait a second, you can't consign this work at auction because you have to offer it to me first. And the buyer says, I don't care, I'm going to proceed. Now, the question is, can the gallery stop the buyer? The answer is, it depends. If the right of first refusal is properly drafted, in other words, it is reasonable, it doesn't give the right to the gallery to buy back over too long a period of time. I would say 10 years is too long. 5 years is probably borderline. 2, 3, 4 years is probably acceptable. Is it clear how it works? If you read the clause in the contract, you understand what buyer and gallery must do if the gallery wants to exercise that right. Because if it's not clear, then it's unlikely to be enforceable. And finally, is it in the right place in the contract? If it's hidden in very small typeface in a strange place in the contract, I would argue that it probably isn't enforceable. So enforceability is key, especially if for you as an artist, this right is important. Do you even know that there is this contractual right of first refusal in the contract between the gallery and the buyer? Well, you don't know if you don't ask. So my recommendation is that you ask the gallery to show you their contract with their buyer, and that will allow you to spot the right of first refusal and to figure out if you think it's enforceable. In other words, good enough. And finally, who is entitled to exercise the right of first refusal? Well, during the relationship when artist and gallery get along well, it's the gallery that will exercise it, and the artist will be happy with that. But what happens when the relationship breaks down? Who then becomes entitled to exercise the right of first refusal? The gallery will say, well, we have the right, so of course we can continue to exercise it. And you, as the artist, might say, wait a second, you are my agent. I am the artist. I am the owner of these works, and I am the holder of the right of first refusal. And I've seen cases where this becomes a bone of contention. And could lead to can result in litigation. If possible, I recommend that you address this upfront and you agree with the gallery. Okay, whilst we get along fine, you exercise the right, but if our relationship is at an end for whatever reason, I want to be able to continue to exercise that right because I consider that this is my right as the artist, not your right as the gallery. Okay, so it's 7 minutes past 5, and I think I will stop now and hand over to Arita. Let's see if there are any questions.
Thank you, Pierre. That was so interesting and so insightful. I'm just checking on the chat. I can't see any questions from anybody, but please, if you do have any questions, now is the time. It's probably a lot of information to take on. If you do think of something, later on today or tomorrow, please do fire it across as an email to us at Bridgeman or ACS, and we'll make sure we can get that answered for you. Alea, have you got any other questions?
Is there an international association that will act in the governing body?
Could you repeat that, Alea, please?
Is there an international association that will act in the governing body?
I'm not sure I understand the question.
Is
What is act in the governing body?
Martin, can you add a little bit more information to your question, please? Instead of one country or another, he says.
I see a good question here. What happens to copyright when an artwork is sold?
I was just
Um,
coming to that one. Yeah.
yeah, well, that's a really good question. The answer is copyright rests with the artist. So the artwork might be sold as a physical asset, but the copyright, which is your intellectual property as the artist, remains with you. Now, you have the right to assign your copyright to the buyer of your work, but I would strongly, if I'm your lawyer, advise against that. It's very important that you keep copyright in your work. You can decide to license your copyright later on. If, for example, the buyer says, oh, I want to create some sort of catalog, or a museum asks, or can we reproduce your artwork because we're organizing a show? And you can say yes, of course, and then decide whether you charge a license fee or not. But copyright really rests. As a matter of law, copyright remains with you, and you should make sure that it's not transferred to the buyer of your work.
I've just a couple more points to say. Bernard is very keen to say that facsimile photography of 2D works usually generates no new interim copyright. Do you agree with that?
It's a controversial topic. Um, well, it depends. Not everyone agrees with that. There are some will agree and say, okay, if it's like a photocopy, then there isn't enough to trigger copyright in the photograph. But I think it's very fact-based, and I can see that there are situations where the photographer has put enough labor and skills into making the facsimile, lighting, etc., angle for the photographer to acquire copyright in the facsimile. It depends what you call what you call a facsimile, I guess.
Bernard, new photo assets can still be protected by contracts, however. But thank you. He says, thank you very much. And then I'm just going to jump to one other question we've got here, which was from Sally, which I have replied in the comments to. Sally, our sister company, the Artist Collecting Society, is a collecting society for the artist resale right. If you would like further information on how to join them, it's completely free to join them. Drop us a quick email after this and we can send you all the information.
We also have a few more questions coming in the Q&A. Would you like me to post those for you?
Yes, that would be. Oh, I can. Where are we?
So from Ellen Owens, if an artist sells directly to a buyer, should they have a sales agreement, and would they then have a direct right of refusal, first right of refusal? Might this also be the case if the gallery does not represent the artist?
Okay, so if you as an artist sell your works directly to buyers, it's really up to you to decide whether you want a written sale agreement. As a lawyer, I would say, yes, you should have a written sale agreement to protect your position, to make it clear that you retain the copyright, although that's a matter of law, but it's always good to remind the buyer that they don't get copyright. To agree price, to agree when ownership passes, when risk passes from you to the buyer, etc. So all the points that I made during my presentation. If there is no agreement in writing, well, there is an agreement nonetheless. The issue is if there is a dispute, then the challenge will be to prove the terms of that oral agreement, and that may not be so straightforward.
That's great. Thank
Who
you.
owns the copyrights when an artist has died? That's another very good question. The law is quite specific about that. Of course, if you have a will, and my advice would always be, as an artist, you must have a will, and your will should address copyright. Who do you want your copyright to go to when you die? But if you have no will, the law will dictate to whom your copyright will pass. I won't go into the details of that because, to be honest, I will have to check. If you don't have a will, your copyright may end up in the wrong hands from your point of view. So do have a will and think about it.
Sorry. Are you looking at Q&A, Aretha?
Yes, I am. So we've got another quick one. Can the gallery discount artworks without the artist's approval?
That depends on the contract. I mean, what I'm used to seeing is the contract between the gallery, the artist and the gallery will have a list of works and a list of prices, and there will be a clause in the contract that says, typically, but not always, that the gallery can discount the agreed prices by up to 10% without having to ask the artist. if the gallery wants to give the buyer a greater discount, then the gallery must seek the artist's consent. And that to me feels reasonable and balanced. If it's not addressed at all, then who knows? And this could end up, in a dispute, or this can become a contentious area. So do decide upfront what are the prices you want the gallery to apply. Of course, taking advice from the gallery, because quite often they will have a view, and agree how much by way of discount they can apply in their discretion without having to ask you first.
That's great. Thank you, Pierre. So another question from Christina. What is the authentication that people are asking now about paintings? So Christina, I'm just going to clarify that one. Do you mean what are the certificates of authenticity or provenance? Is that what you're referring to with this question? I'm guessing. Like, what are the key? So Pierre, what would the key provenance documents that most people would require now when selling an original artwork?
I would say my answer is that the artist has to decide once and for all how they will convey the fact that they are the author of the artworks. Is it just by signing the artworks? Is it by applying a stamp on the back of the medium? Is it by issuing a certificate of authenticity? You have to make a decision, and then you have to apply that consistently. The worst that you can do, in my view, is an inconsistent approach. For some works, there's a certificate. For other works, you sign them. For other works, there's nothing. Because that's a recipe for disaster in the long term. Nobody will really know what you were up to in relation to any of your works, and that will not be good for your legacy later on. So make up your mind, ideally record in writing how you will authenticate, or how you will convey to the world that this work is by you, and then stick to it. And also, do not allow your galleries, to issue certificates of authenticity. That's not the job of a gallery. It's only the artist. Again, this is my view. Only the artist should and can issue certificates of authenticity.
And we're just going to do a couple more questions now, and then the rest you can all email them directly to press@bridgemanimages.com, and we will forward those to Pierre to answer. But just very quickly, Pierre, in the case of an express trust, who would be the trustees in an express trust, and is it expensive to set up?
No, it's not expensive. I mean, this, it's you need to have the right language in your agreement with the gallery. The trustee will be the gallery, and they will hold your share of the sale proceeds on trust for you. The point here is that the gallery doesn't own your share. It acts as trustee on your behalf for your benefit. But that trust, it's not complicated at all, but you need the right language, and there needs to be language. So you can't agree orally with your gallery that the gallery will hold your share of the sale proceeds on trust. It has to be in writing.
That's wonderful. Thank you. There was a couple of questions. One artist wanted some advice on a lawyer based in Singapore. So I'm going to forward that one to Pierre directly to get back to you on that. And Kitty, I think you've got quite a complicated question. So again, I'm going to send that directly to Pierre, and Pierre, he can get back with a bit more time on his hands. I just want to say thank you so much for everybody who attended today. I thank you so much to Pierre for your wealth of knowledge. It was fascinating for me. I had a gallery for 12 years before working with Bridgeman, so I feel like I've learned a lot that I probably should have known. And as I said, please, if anybody has any more questions, you are welcome to answer those. And if you can just email them directly to press@bridgemanimages.com, that would be excellent. And we will be making the recording of this talk accessible on our YouTube, and we will circulate the link to everybody that signed up to join today. So thank you again. And yeah.
Thank you, Rita. Thank you, Alea, for organizing this session. It was a pleasure. And yeah, I look forward to receiving the additional questions in due course.
Wonderful. Thanks a lot. Take care.